that is the role of experts in pretrial litigation efforts. After covering some issues associated with the retention and use of experts in cases, I'll kind of transition and get ourselves even closer to trial and discuss motions in limine, something that we touched on earlier today. With respect to experts, I'm going to kind of go a little bit out of order even from some of the materials because I wanted to kind of pick up off of the discussion about depositions from just a short time ago. Assuming there's an expert in a case, that expert most certainly will end up having his or her deposition taken, and the deposition efforts of an expert are a little different than some of the kind of rules of the road we were covering with respect to depositions more generally. In the expert context in particular, there's a couple things to really keep in mind, and then we'll kind of move back into just expert disclosures and other issues. One is don't out-expert the expert. It's just not possible. As true as that is at trial, it's also true at a deposition. That is, there's just no way to master a field to the depth that an expert would in any area, whether it be accident reconstruction, financial analysis, or anything else. That's not to say not to be educated about those areas, but don't try and outsmart the expert. It's just not going to be an effective use of your time, and it's ultimately not going to really get you all that far. What your focus should be in deposing an expert, one, going back to the general description of the concept of discovery, that is just discovering information. So here, although you most likely would have, through discovery efforts, either a written report or a disclosure as to what the expert's opinion is about whatever they're weighing in on, you want to find out what lies behind the opinion. Literally, what did that expert review? What did the expert not review? What emphasis did the expert put on any of the materials that are within the expert's inventory? So were there some things that were provided that were not material to the decision, other things that were provided that were kind of preeminent in forming the analysis that the expert is now testifying about? That's somewhat of a housekeeping exercise, but can be very important. Fast forward, let's say, to a trial or some other hearing where the expert's testimony is going to be introduced, the ability to identify the facts that the expert found to be marginal. If the fact finder, judge or jury, believes that those facts or those instances have much more weight than the expert gave them, that kind of inherently starts to undercut the weight or value of the expert's testimony. In addition, when you're deposing the expert, in addition to finding what their opinions are and what materials went into those opinions, also figure out what their opinions are not. Again, seems somewhat basic and housekeeping in nature, but confining the scope of the expert's role can ultimately be very helpful, because as the case evolves, it may be that kind of the turning point in any kind of trial really rests on an issue that the expert conceded at deposition months before was something they were not super focused on or was not what they were opining about. Go into what the expert was not provided is an additional path to take to try to come up with some assumptions where you're able to kind of poke holes in the expert's process. That is, if the expert was given the deposition of the plaintiff and the defendant, but you weren't given the deposition of the accounting folks from one of the parties, or some other source of information that may or may not have impacted the expert's testimony or analysis, is an additional way to color the validity of that expert's opinion. That in no way is questioning the person's credentials or that they're not intelligent or that they didn't actually do a good job in the analysis that they performed, but suggesting that the analysis might be relatively incomplete. And most experts, in my experience, are pretty forthright in terms of if an additional fact were offered, would that have an impact or not have an impact on the person's conclusion. So keep all those things in mind when you are deposing an expert, in addition to some of the things that become somewhat inherent about your particular case. That is, have they worked for this plaintiff before? Have they worked for these lawyers before? How many times have they been an expert for a plaintiff versus a defendant? Have they ever testified before? Have they ever been subject to a Daubert motion? We'll talk about Daubert in a few minutes. And a host of other things that go to the person's credentials. Generally, it is pretty helpful to figure out exactly what they were provided and what they were not provided. So let's jump in on the experts generally. Do you need an expert in your case? Not all cases require it. If you choose the right expert, it can be very helpful because it relieves some of the pressure or burden from your client or your client representative and allows the expert to share in some of the heavy lifting. They're not the lawyer, it's not their case, they're not the ones who are leading the charge, but for purposes of allowing your fact finder, arbiter, judge, jury, some additional perspective on kind of the who's right or wrong, an expert can be hugely valuable. In my experience, I think juries tend to put a great deal of weight on experts because that person was groomed and trained in that area. And in the right circumstance, the expert can almost serve as another advocate because the expert does not come with a warning plastered on their forehead that the judge will give a jury about things that I say or Jim will say. That is, remember, what the lawyers say in this courtroom is not evidence. You're only supposed to get it from the witness stand. And here you are, you put someone on the witness stand who's kind of opining on kind of the crucial pieces of your case. So it can have great weight. In the expert arena, we're working off of Federal Rule 702. Most states, in my experience, have adopted rules, if not right in line with 702, something that's pretty darn close. And the test for if you need an expert is really just going to be, essentially, is it going to provide a path for the jury to have a greater appreciation for the issue at hand or to do their job? I mean, it's a very kind of vague description, and judges have articulated it in a series of different ways. But if their role or if their explanation of a concept will enhance the fact finder's ability to do their job, then you're going to find yourself in a situation where an expert can be pretty helpful. They're not always required. There are certain areas of opinion testimony that do not require an expert, and even a lay witness can give an opinion. One that comes to mind is value of property. For me to opine about the value of a home, in Atlanta is something that I don't need to haul an expert in for. I'm perfectly capable and legally capable of giving that testimony. And then it's only subject to the credibility or attack on how I reached my opinion. In 702, there are subcategories in there in terms of describing what falls inside and outside. But your scientific specialized evidence is kind of your normal run-of-the-mill motivation to go get yourself an expert. In selecting an expert, there's a lot of kind of non-legal training, if you will. To Jim's comment earlier about some other things, they didn't teach you this in law school, is trying to pick an expert. Trying to find the right expert for your case can be a big challenge. Just because peers of yours have used a certain person may or may not be the right circumstance. But finding an expert who can not only grasp the issues at hand, but can articulate those issues coherently in a way that a lay person can understand. And that's a big difference. if the expert is trying to explain his or her opinion to one of their peers, so let's say another engineer or another physicist, that's fine, but you're not going to have a jury of engineers or a jury of physicists who are the receivers of the opinion. So you need to find someone who's got the personality traits that make them capable of communicating to lay people concepts that lay people generally are not exposed to on a regular basis. That's kind of the whole point of having an expert in the first place, is to try to get your arms around a concept that otherwise is not naturally kind of thought about by fact finders in the first place. In terms of who's going to be the expert, in terms of making sure they are qualified, of course, that's a gatekeeping feature that the trial court is going to do, and that's only done at the appropriate stage of the litigation. So let's going back to choosing the right expert. Right, so think of some of the obvious sources. You have kind of your professional experts. They're almost wound up toys in the sense that this is all they do. They're very quick to get up to speed. They can move pretty quickly. The idea of being deposed does not faze them at all. And they are well accustomed to explaining or teaching a jury about their area of expertise. And the largest, most obvious drawback is they tend to cost a little more because they've been doing this a while, so they're well heeled. And you do run the risk of the expert being considered literally a hired gun, and that's all he or she does is testify all day. If someone deems them to be the professional witness, that tends to just kind of put a pall over what they may testify about. Also, you need to be very clear or very certain that you have vetted all of this expert's opinions in other cases, people who are testifying a lot. So let's use a structural engineer comes to mind. If they're testifying in 10, 20, 30 or more cases over the past several years, you have to go figure out if they have given an opinion that contradicts the opinion they're going to give in your case. You talk about something that's just more practically fatal to your position, and if you don't go find it, you have to assume that the opposing party in your case is going to go find it. One other source, of course, is academia. Very bright, very well educated, certainly up to speed on all the latest trends and concepts in a particular field or area. They tend to actually have the extra time, particularly if you can work around an academic schedule. Their fees can be more flexible. One of the drawbacks with academics is the fact that they are academics, meaning they may not have the greatest connection to how these concepts apply in the real world. I'll use a financial concept, for example. If that person hasn't been inside a company in a long time or hasn't really drilled down into the details of a profit and loss statement or other things, using as our early example the loss profit analysis. If they haven't worked at a company that's drawn a profit in 15 years, they may not be the best source for articulating, what the lost profits would have been because of the breach of this contract. Then the polar opposite of the professional expert is kind of your occasional expert, someone who testifies fairly infrequently, but they have a unique or distinctive expertise that really qualifies them to offer expert opinions. They tend to cost a little less than your professional experts. Their credentials tend to be still strong. One of the greatest risks is that they are not accustomed to the legal process. So yes, they're confident in their ability to assess the structural integrity of some building, but in terms of having the skill set to translate that into a deposition, dealing with adverse counsel, and articulating things in a way that a judge or a court or a jury would recognize is sometimes lacking. Once you've selected your expert, then you have to figure out literally how to get him or her up to speed. keep an inventory from day one as to everything you give your expert, so that there's never a question as to what went into what database, if you will, of information was available to the expert for their review. The scope of the expert's information is certainly something that's going to be probed in discovery, and you being able to maintain an accurate inventory of what the expert got and when is crucial to having reliable capabilities of responding to that question in discovery when it arises. In terms of the expert's opinion generally, the opinion must rest on items that are otherwise capable of being admissible. That doesn't mean it has to be admitted. It just has to be capable of being admitted. And that distinction sometimes can trip people up, but you don't have to put into evidence every single thing that the expert's going to be working off of. But just be sure that it's something that otherwise could be admitted. One exception to that is if an item would be otherwise inadmissible as long as it falls into a category of things that are typically relied on by experts in this field. So if your expert can say, look, everybody like me goes to this source for some information, that will also satisfy your requirement because it has that degree or grain of credibility rather than an expert just kind of making things up out of whole cloth. And some of this you can find in 702, some of this you can find in 703, particularly the discussion of an expert kind of going outside the realm of admissible evidence in utilizing sources for their opinions. In the meeting with experts, and this is something, again, it's not written down anywhere, but something I've come to just experience sometimes firsthand, and it almost becomes more obvious the times that you don't do it as well as you wish you had. Going back to my be a good listener, we're always the ones who are taking control, doing all of the talking. When you're evaluating the experts, and then even once you've selected an expert and you're kind of moving along into providing evidence and getting them information so they can form their opinions, stop for a minute, take a deep breath, and have the expert start explaining to you kind of how things work. I was involved in a trial in the last several years involving some very complicated office lease expense issues. And for reasons that are a little bit surprising maybe, but the need for experts was apparent in the case. And just stopping for a minute and saying to the expert, okay, tell me how to do this. Like, what does this mean? And then asking the next questions and stopping and listening, which is, how do you know that? Have you ever done this before? When have you done this? All things that you know are coming in a deposition at some point, but will really help you, one, understand just how the real world works in these issues. I don't work in office lease world every day, but people like, commercial brokers do. What the terminology is and those sorts of things. But if you just kind of slowly go through, don't, as Jim suggested, do what this party did and just jump to, well, if one expert's good, then two experts is twice as good, and then three must be triply as good. But slow down a little bit and even ask the expert, okay, what can you tell me about this story? What has your experience has been? Because that will help you evaluate really the depth of that expert's ability to convey themselves so that your local community college professor may be the better person. Because all of a sudden you're like, oh, well, he sounds like a real person. He doesn't sound like a wind-up toy who's done hundreds of these cases. All of that is going to get you to trying to select, if you need an expert, the right expert. And it really, I can't emphasize enough that trying to identify the right expert, how much energy that takes. I think folks who do a good bit of med mal work have probably cornered the market on this. It doesn't always work on the plaintiff or the defense side, but in terms of that commitment of evaluating the expert, spending time with him or her, really sifting through their opinion, not just that they reached an opinion that's consistent with the defense theory of the case or the plaintiff's theory of the case, but why and how they got there, and using that to help analyze whether that expert's the right person for the case is something that we all could learn from and adopt a little better, which is take some time to really understand why the expert believes what they are telling you. Once you get over that hurdle and you're kind of marching down the road of having your expert, we are just prone to having rules that govern everything we do, right? We're kind of just second nature for us at this stage. You find yourself sitting in a rubric, whether it's under the federal rules or a comparable state system. Federal Rule 26 is going to lay out the expert disclosure rules in terms of what a party must do to fulfill their obligation as a litigant who's going to rely on an expert witness. So you're talking about making your disclosure either consistent with some local court rule or 30 days after the other party's disclosure if you're identifying an expert for purposes of rebuttal. So that would be in the case Jim's talking about if his rules were, as I'm identifying the federal rules are, all of a sudden plaintiff starts identifying a series of experts on a variety of issues, then it's kind of Jim's client's turn to make the assessment at that point whether a rebuttal expert is necessary. On the local jurisdictions, you may have differing rules, and then in my experience, even in the federal system, a lot of judges have their own kind of scheduling orders that they use that they believe effectively manage parties. I think on the state court level in particular, we're seeing more and more judges implement scheduling orders that have certain deadlines in place to push people to reveal their experts as early as possible, and not only reveal them, that's just the threshold issue, but then provide all of the substantive data that goes behind that expert disclosure, putting the opposing litigant in the best position possible to assess the opinion, including whether a rebuttal expert is necessary. So we're staying inside of Federal Rule 26 for a minute, but 26(2)(b) will spell out all of the things that a written report for an expert is required to include. They're pretty vast. A lot of them are things I was identifying earlier about the facts considered by the witness, right? So that's some of your inventory. But then it goes a little further, and some of this is a huge challenge in terms of getting a lot of this stuff complete in a way that your expert's comfortable with, but also is going to satisfy the 26(2)(b) requirements. That is, any exhibits that the expert might use to summarize the opinions, that's a pretty big deal. And then the witness's qualifications, that's frankly fairly easy. Publications authored in the last 10 years, cases where they've testified over the last 4 years, how are they getting paid, are all things that should be included in your expert report. And I think most state jurisdictions are utilizing disclosures very similar to what 26(2) is imposing upon parties with respect to disclosing the report. So that gets us into some funky areas, frankly, is what you do with these expert reports. You know, when do you want to have them generated? How are they generated? Earlier we were talking about, with respect to certain discovery issues, kind of like discovery inside the discovery. There's certain things that people just tend to, certain battlegrounds that you can predict. The documents and information associated with an expert's presence in a case is a frequent area where people tend to just kind of start drawing battle lines. So that would include communications back and forth with your expert. You know, are they supposed to be disclosed? Are they not supposed to be disclosed? And I think the starting point is going to be it's all getting turned over. There are exceptions for mental impressions and theories of counsel, but I think the better practice is to go into the commitment to utilizing an expert to assume that everything that you send to that expert is getting seen by the other side. So word your emails carefully. On the expert reports, you can amend them. I mean, I'm not suggesting that's a rule that you want to start following, that is just slap something together to get it out the door. But if things happen during the case where the expert's going to modify their assessment, don't be afraid to go back and put a comparable modification in the expert report. In fact, it's probably required in the right circumstance. But don't be so hung up on, oh my God, they're going to accuse my guy of changing his or her mind. All it is an explanation. And, well rehearsed, the expert can say, I had no idea that that was true. But the other side ended up revealing halfway through the case this fact. So of course I wanted to take it into consideration instead of ignoring it. You've kind of turned something in, potential negative kind of into a positive. The expert concept is phenomenal. There are some jury charges that will come with the use of experts in terms of what their opinions mean and all that. Jim brings up a good point about, sometimes using an expert to kind of mask a flaw in your case or a piece of your case that is otherwise lacking. It's actually a pretty good strategy. I would say not to the extreme that he was identifying this one party did. But experts can help bridge a lot of gaps, especially if you use the right one. It's a neat tool. My experience has been, if presented well, juries tend to be big fans of experts and really will kind of not follow their lead. As long as the experts, again, are not reaching for the stars, so to speak, it can be an effective way for you to have an advocate even on the witness stand. So inside of the identification of experts, however, everything has to be kind of examined through the Daubert Principle. So Daubert's the shorthand name, and I'm sure it's a lawyer mispronunciation of a French litigant's name in this case from the U.S. Supreme Court from the early 1990s. But it has become the bellwether standard for the use of experts under the federal rules of evidence. When Jim and I started law school, Fry was the name of the case that controlled a lot of expert things. And then once the Daubert decision came down in the early 1990s, everyone kind of shifted their focus to Daubert, and that in terms of what constitutes an expert whose testimony is admissible at trial. And it really turns on whether that person's opinion, again, is going to be helpful to the jury making its ultimate decision. Different states have put certain criteria on that. For example, in the medical malpractice world, if you have to be from the same discipline and things like that, all will go into your Daubert analysis. But it's all designed to be a gatekeeper function by the trial judge before the expert is ever sitting on the stand during trial. In the Georgia system, there are some timing requirements that if you are going to engage in what's called a Daubert challenge, that is, criticizing the expert's reliability or capacity to serve in the case, there are timing requirements that upon that expert being identified, the clock starts ticking for you to run in and make a challenge, as opposed to playing that game, on day 2 of the trial and standing up and saying this person's not eligible for these reasons, I want to challenge them. So just beware if your jurisdiction has some specific timing requirements that may limit your ability to control when or if an expert can testify. One other thing, especially in the state system, if you don't have these specific Rule 26 kind of guidelines. A lot of the state procedural rules are a little more lax and lacking some of these scrutinizing hoops to jump through. At least in Georgia, up until we enacted kind of an updated Daubert just in the last couple of years, frankly, parties were able to identify experts up until the commencement of a trial. So can you imagine trial starting on Monday, Friday afternoon with no pretrial order entered, because some judges would never enter one. I'm sure Jim's experienced the same thing. All of a sudden, an expert disclosure comes sailing across your email, or back in the day, a fax machine on Friday, and you're trying to figure out what do you do. Under the Georgia case law, very interestingly, exclusion of the expert is not the remedy. Delay is. So that, under the idea that it affords the litigant the opportunity to vet the expert, all with an eye towards getting to the, quote, right answer, as opposed to the fast answer, which we can all appreciate just how unbelievably infuriating it is to get all the way up to the eve of trial, and your only remedy is to kick the can down the road a few more months and try your case later, when you really want to just say, look, they're playing games, throw the expert out, let's start our trial Monday as we planned. So just beware of any timing requirements that you may have in whatever particular jurisdiction you're in for when you need to reveal an expert, and if you have obligations then to respond in kind with either your own rebuttal expert or to challenge the expert or experts in Jim's instance that have been identified. So we talked about Daubert as being the vehicle, kind of the nickname, if you will, for the vehicle of filing a motion with the court challenging the expert's eligibility. And that's not the only pretrial kind of motion that I would encourage you to contemplate when you're pushing your case through as discovery is kind of rounding out and you're now looking forward to the next event in your case, which is getting your case ready to be tried. Motions in limine have become, for me, one of the many kind of pretrial tools that I'm a huge fan of. They can run any number of topics, and I have found them to be enormously helpful in my trial preparation. I probably early in my career, I used to almost envision them as either kind of gamesmanship tools, because I would see lawyers filing them just in the day or two leading up to a trial, or I saw them almost as a sign of weakness. That is, oh, he or she is afraid of this piece of evidence, so they're running in seeking to exclude it, which is a vast kind of misunderstanding of the role that effective motions in limine can serve as you're trying to get your case ready for trial. Really, throughout the day-to-day, you've heard us talk about kind of even back on Jim's initial case assessment, looking at issues really kind of out of the gate. And then throughout the day, if we've talked about the different stages of pretrial civil litigation, we've really encouraged you to constantly kind of have a plan. You know, why are you writing these otherwise seemingly boring interrogatories? What's the point of this set of requests for production of documents? Why yet another open records request? What's the goal with this particular deposition? And a lot of that is all culminating toward a motion in limine or motions in limine. Rather than be the one who files them 2-3 days before a trial is supposed to start, don't be that person. File them early. File them a month or two before the trial if you have that much time. That is, it should not be a surprise to you that there exists a certain piece of evidence in the case that you're either seeking to exclude or that you want to be certain is going to come into evidence. So why not just ask early? The worst thing that happens is you lose the motion and it's not coming in, But wouldn't you rather know that 60 days before rather than 60 minutes before? Because how many of us have had the motions in limine just rolled into the Monday that you're going to start picking a jury, and the judge says, anything we want to cover now before we start picking a jury, and you start hammering through some potentially crucial evidentiary issues. How are you going to react and adjust to that on the fly? Whereas if you had known ahead of time, it would be just, again, for better or worse, at least you know what you're dealing with and you can react accordingly. Get them out there. And that's really probably the greatest piece of advice from the motion in limine. From my experience, both in state courts that I practice in Georgia and in other jurisdictions, as well as the federal courts, the motions in limine are not a work of art. This is not the summary judgment motion or something, or the appeal brief that you will toil over and wordsmith each phrase and each comma. They tend to be much more bullet oriented. Sometimes I have literally written them in bullet form because it's fairly black and white, right? That doesn't mean this not without case law and other things, but it should not take you pages and pages and pages and pages to explain some very discrete issue about a certain document, or the character evidence that we talked about earlier, or whether you fit within some other weird hearsay exception for a particular piece of evidence that you want to try and get into the case. So just ask. And then, and we've all been in this situation, you need to kind of maybe politely cajole the court into making sure that that motion doesn't just get rolled to the morning of trial, and really telling the judge why it's of great importance that this stuff gets ruled on early. I've really had no trouble having my motions in limine heard early when I have filed them early. Even if it's only a week or two out at some pretrial conference, boy, that's just light years of reaction time short of learning that Monday morning as you're about to go pick a jury. So I put in the screen here some areas that I tend to go to. I have certain kind of go-to issues. Admissibility of evidence is pretty easy. Conduct of parties is pretty simple. So there's one you don't really think about. I'll give you a quick little war story. I was going to try a wrongful death case that's not my area of expertise with a dear friend of mine. He was going to help try the case for me. It was a longtime family client of mine. Their son was killed in a horrible accident. We were about to try the case. He's the one who really keyed me into the motion in limine issues, and we dealt with them months ahead of time. And he said the one he always used, and I've kind of pirated it from him, is the no one can say they're sorry approach. That's obviously a plaintiff-bent motion to be filed. But what he's trying to avoid is any defendant throughout the trial making reference to anything that could be characterized as a regret, I'm sorry kind of statement. And there's some evidentiary rules that suggest that's not appropriate. So it's a very well-founded motion. The concept being, though, boy, once that witness utters a phrase that could even be interpreted along those lines, yikes. Putting that proverbial genie back in the bottle is almost impossible without you reminding the judge and the judge reminding the jury that someone said they were sorry and that they're not supposed to consider that they said they're sorry. You just don't want that kind of context ever permeating the jury's analysis. There are some other ones that I tend to use also, unrelated prior claims. I just can't run the risk of a witness popping off about, well, this is the third time that someone's been mad at them about such and such. The apologies is in there. Any discussion, because I do some work in the financial industry, financial institution and financial services world, I want to make sure that there are just not any discussions about the industry. So if you're on the plaintiff side, you might want to make sure that someone like me doesn't use anything that can be interpreted as, please don't cream us in this case because not only us, but all businesses like us in this industry will be similarly adversely affected. Same way, I don't want anyone talking kind of junk about banks or other financial institutions, whether it be vague references to the crash in 08-09 or anything like that. I don't need too big to fail and all of those trite phrases that have ever been used over the last decade kind of criticizing banks to be used in a case I'm going to try for a financial institution. And there are other issues that would come up along the way. Again, some of the obvious ones, financial circumstances of the parties and those sorts of things. Although some of those seem so obvious, the audience, you lawyers, you guys know that you're not supposed to talk about the financial wherewithal of a party and that's not relevant in a case. And I know that, and Jim knows that. But the witnesses normally don't know that. Can you assure me that every witness who's going to testify in your case knows that they can't make a remark about poor Jane who lives in this modest neighborhood and they got hit by a truck driven by, where the massive national headquarters is down the street? And they may just say it because they feel really sorry for Jane and they've run headfirst into an area that we all know is prohibited. This poor witness has no idea. But if I vetted that ahead of time, I also always include in the motion something that's in the middle of the screen there, an order that directs the parties to inform the witnesses of all the rulings on the motions, and that the witnesses are obligated to abide by them. Now, what reasonable lawyer can tell a judge, well, we don't need you to rule on that, because I just get to say, well, let's just have it as a ruling. It's no problem. I'm bound by it too. And I've really had very little. I've had one lawyer in all my years of filing that motion challenge it as basically being ridiculous and unnecessary. To which I just said, well, can you guarantee me that your witnesses won't violate any of these? And he said, no. I'm like, all right, fine. I need a court order directing the witnesses not to violate them. And let's talk about why all of that is important.
Before you move on, Chuck, you made an excellent point about when you and I probably first started practicing, the norm was that motions in limine would be heard the day before trial or the morning of trial, and your point about, these are important, they're going to shape what you're going to do. Heck, they could impact potential settlement discussions and all those things. And what I've seen now is that with the changes in the federal rules that have trickled down to the state rules, that the parties have much more input on scheduling. And again, you need to look at your case prospectively on the front end to say, is this going to be a heavy evidentiary case where I'm going to have some of those things on the front end? Because you want to say to a judge, and I've never had a judge say, no, Judge, I'd like a set-aside motion in limine hearing a week before. And judges are going to give you that. I've never had one refuse. They're going to give you that because they are thinking the same thing you are, which is it allows the parties to properly prepare. It gives the court another chance to potentially get the case settled, depending on what the rulings are. And it prevents the last minute stuff or potential last minute request for a continuance or those kind of things if you're hearing all that the morning of. And I've done that before. The morning of trial, you're hearing 10 motions in limine in shotgun type, machine gun type fashion, and then you got to go tell your client in the hallway, well, here's what the judge ruled on everything. Oh, let's go in there and start. That's just no way to conduct things. So I appreciate your comments in that regard.
With respect to the motions in limine, if you are fortunate, as Jen was mentioning, making the request to the judge ahead of time and saying, in so many words, we're pretty on the ball. There are some important issues in the case. We'd like you to set aside some time for us. I have now developed, really at the encouragement of one of my partners, she showed me a little kind of a box that she creates. So when you have the motion in limine hearing, she comes with an order already drafted. But it's not a long, lengthy order. It's literally a bullet point. A will be, if I go back a screen here, conduct of the parties. Let's say that's one of them. Order directing the parties to abide by the motion. And whatever ones that are included in that particular case. And then it just has kind of columns next to it. So just a phrase mentioning the issue. Columns next to it says granted, denied. and with a little bit of space for the judge to scratch in a commentary or something. And then we show up at the hearing with this, because that's literally what the judge is doing. This stuff is fairly discreet. It's like, yes, Jim, I agree with you, granted. Now let's go to B. And then they just kind of knock it off, and no one has to mess around with writing an order or anything else, but having that clarity. So you have that order just sitting on the side of your trial table the whole time, just gives you additional comfort that these issues have kind of been dealt with. But I agree with Jim. I have seen a trend where judges are very receptive to hearing this stuff early, because it signals an effort to try your case as smoothly and as efficiently as possible without a bunch of breaks and jumping up and down and clearing the courtroom and sending the jury out and then running around for an hour fighting over some cases and a whole bunch of nonsense that makes the trial very clumsy and inefficient, which is one thing that would just tire a judge's patience pretty quickly. So I was getting to, why do we file these? Well, obviously it's to control evidence and those sorts of things. It's a preservation issue for appeal, is kind of the hidden gem with the motion in limine. There are cases like this in Georgia, and we put some in the materials here from the First Circuit, that if you have gotten a final ruling from a judge on a particular issue, then you have satisfied your obligation to preserve that issue for appeal. That's huge. And let me tell you why that's way better, even if you lose the motion. Far better than doing it on the fly, Tuesday afternoon of trial, Wednesday morning of trial. Witness starts to talk about something. My example of the witness popping off about how big that company was who hit her poor friend, right? And I have to start jumping up and saying this and saying this. All of a sudden, in addition to being disruptive, I am flagging issues in the case that I don't want the jury to hear about, but I'm actually drawing attention to them, and essentially I might as well stand up with a sign that says, "Jury, I have no desire for you to hear this information. That's why I'm yelling so loudly. Please pay extra attention to it." Under the Georgia appellate courts, they've come up with a ruling that relieves you of any obligation to object to that line of questioning during the trial if you have obtained a pretrial ruling on a motion in limine. So you can just keep your mouth shut. It's possible that the evidence doesn't have the impact that you feared, but at least you've solved your problem of making sure that issue's preserved for appeal. Balancing the good experiences Jim and I have had with courts being receptive to hearing motions in limine early, please be aware, however, of, they must teach this in judge school or something. That is, the judge saying, well, let's just see how things unfold. We'll take it up as it comes. That's not a ruling on your motion in limine, so it's still open season. They've just literally kicked that can into day 2 or 3 of the trial, which puts pressure back on you. Maybe you have to object in the middle of that witness's testimony about some item, or object to that document and lose your objection right in front of the jury. There's a tactful way to push a judge to rule. Again, even if the ruling is adverse to you, it's something, again, that you can control. Please push for the ruling. Then you have the protection of the motion in limine kind of sitting behind you. And don't ever kind of underestimate, how these motions have an impact. Jim mentioned that they have a great impact on the settlement capabilities of a case. If you're able to keep something out, it may lessen someone else's view of their case, and vice versa. You may tell your client, look, I did the best I could, that some of the things that Tim did right around the time that he left the company, I told you they might come back to haunt him, and our greatest fears are being realized. That is going to come in at trial. I'll do my best, but you just have to know. And that may motivate people towards kind of reaching a resolution. And I can tell you all kinds of different stories on these weird issues I've had come up about motions in limine, but they are a great fodder for it really should be the culmination of all of the analytical prep work you've been doing throughout the case. So like Jim was saying, you've known for however many months that such and such issue is going to be important. So just bring it to everyone's attention, put it out there. You've probably done the research on it already, and kind of push it out there and really kind of see what you can get out of any kind of pretrial ruling. If you name the issue, I have probably litigated it on the motion in limine. I mean, we're talking about some really funky stuff, including, I mean, all kinds of very touchy subjects. I had cases where a party had an abortion and I wanted to keep it out. It was a financial case, but it was one of those where I can't have that come into the trial for fear that one juror may be impacted adversely. A lot of habit and custom stuff tends to come up because that can really swing someone one way or the other if they know that, you know, someone's character gets impugned on the stand. It's very difficult to rally from that. One subset to the motion in limine, if you're in the judges will delay and be dismissive until trial, that let's see how things unfold approach, consider your fallback after you've gently pushed and then pushed some more for a ruling and you can't get one. Signal to the judge your desire to do a proffer. And that's particularly when you're trying to get a particular thing into evidence and the judge just isn't buying why he or she might let that happen. And so a proffer would be clear the courtroom, no jury, witness on the stand, and you run through what essentially is a dress rehearsal of sorts on that particular issue. The witness is subjected to cross-examination, and then based on what the judge has literally heard from that witness, not my description of what the witness would or wouldn't say, they can assess whether it is, for example, close enough under a similar transaction type instance that it is going to come into the case or it's not going to come in. I've had some good experience with that under that exact example where some financial fraud cases, I was trying to establish kind of a pattern that the fraudster had done this to other people using similar MO, and I couldn't get the judge to rule affirmatively that this witness could testify, so I used my fallback and said, how about when we get there, I want to do a proffer of this witness. You can assess from the witness yourself, you know, exactly the similarities between the two, and at that time, you can decide whether to allow the witness to testify. In that one instance, under my rule that people only tell war stories where they were successful, the proffer worked and the judge ended up allowing that person to testify. We've covered a lot with respect to depositions generally, transitioning into experts, the role of experts, including the deposition of experts, either for you or against you, and then taking really the culmination of a lot of that work through all the discovery efforts, and extracting from that some peculiar issues that came up during your case and how to fashion those and get those to a court in the form of a motion in limine. Before we move on to the next phase, which is using pleadings and such and motion practice in the case, and wrapping up the day with some ethics, we're going to take a quick afternoon break, and then we'll be back and we'll conclude our afternoon session with you. Thank you. Welcome back from that short break. So we have 2 sessions left before we finish the day with you. One will be about the use of pleadings and the role pleadings can play, including motions, in the effective handling of civil litigation. And then Jim will finish the day with an ethics discussion that kind of touches on a variety of the things we've actually covered throughout the day. So we'll talk first about using pleadings, motion practice, and those sorts of things as part of the civil litigation kind of toolbox, if you will. Some of this, again, like some of the other items we've covered earlier, I'm going to do in kind of a little bit of a state versus federal procedural kind of contrast in terms of using pleadings and being aware of some things in either properly creating pleadings or using certain flaws in pleadings to your advantage. For the most part, from my experience, state courts have now been drawing heavily from the federal rules of civil procedure. Even if not adopted in toto, most of the kind of large milestone rules that we're accustomed to utilizing in the federal system appear in some form or another in the state system, which is fairly helpful, particularly when it comes to navigating through some civil procedure concepts and the strategies that may come with those concepts. From a pleading standpoint, with respect to damages, in his presentation earlier, Jim was highlighting kind of a quirk, if you will, in the Minnesota pleading requirements for a claimant to seek the recovery of punitive damages. I'll use that as a good example of kind of a know your audience, right? Know what local customs or state-based rules are in place that may impact how you need to best craft your pleadings. And in my experience, I'll mention in Georgia, for example, there are a very limited number of claims that necessitate a verified complaint. There's only a few, but because there's only a few, it's something that I'm very kind of in tune to if I see something come across my desk that's not verified. One of the interesting ones, not to give you a Georgia civil procedure rule, but a simple suit on account, actually, if verified, puts certain obligations on the responding party where they can't do kind of that blanket denial, which is really just a stall tactic because they know they owe the money, but they just don't feel like paying the money. There are pleading requirements that obligate the defending or responding party to articulate in considerable detail what amount they are willing to concede is owed. Again, just a little quirk. I think I've seen that creature appear in other state civil procedure rules, but it's just kind of an interesting example. Complaint is filed. I'll state the obvious. Figure out how long you have to respond, because it may not always be the same. Georgia has started utilizing a means much like the federal system, where if you are willing to go through the waiver of service process, you can buy yourself a good deal of extra time. Curiously, I think even when I started practicing and when Jim's been practicing for a while, using an acknowledgement of service, we just say, don't send the sheriff to my guy's company, I'll just acknowledge for you. Under the Georgia rules, that is not a waiver of service, so you're still under your 30-day answer time period, and there's actually been a substantial case out there where someone kind of confused the two and utilized the longer time period. But anyway, you have whatever your proper response time is, figure out if you have to do a verified answer. Usually if the complaint's verified, you have to have a verified answer. In addition to articulating whatever applicable defenses and so forth exist, let's start talking about then in the what's next category. If you're doing your answer, you need to identify whether the claims have been adequately pled. I think most state jurisdictions are starting to take heed from the Iqbal and Twombly cases from the U.S. Supreme Court about the sufficiency, the detailedness, which I don't think is a word, but the specificity required for an adequate pleading that will stave off any kind of motion to dismiss or motion for more definite statement. With that particularity, I think I'm seeing really is being adopted in all state systems in some form or fashion. So you'll need to assess, has the plaintiff adequately spelled out the claims, leaving you in a position where you are capable of responding. If you're the plaintiff, be very certain to balance the detail that Iqbal and Twombly are suggesting is needed, but never losing sight that we still remain somewhat of a notice pleading platform. One of the first things that you're going to need, that decisions, if you will, that you'll confront in analyzing a case when it comes in that's been filed against one of your clients is whether to pursue any kind of motion to dismiss under the Federal Rule 12. And there's a host of them, articulating various grounds that can be filed to challenge the sufficiency of the complaint that's been filed against your client. In addition to the motion for a more definite statement or motion to dismiss under the Iqbal or Twombly standards, there are a series of other avenues to consider in assessing your rights that Rule 12 grants. Under the federal system, remember that if you file a motion to dismiss under Rule 12 within your 21 days, everything is suspended in the case. No discovery. You don't even have to file an answer until the motion is ruled on. So in the right case, staving off the time when you need to commit to a position, whether you're going to admit a certain paragraph, deny a certain paragraph, and make other decisions in terms of responding to the initial complaint. If a motion to dismiss will buy you extra time to make that decision, then a Rule 12 motion, if you have the grounds, we'll talk about that in a minute, can be a really valuable tool. A weird little quirk, Georgia just recently has adopted this Rule 12 idea that the presence of a motion to dismiss can stall the commencement of discovery, but Georgia's put its own unique spin on it. Party still has to file an answer, so you're not relieved of your obligation to kind of, pick a position. And discovery is only stayed for up to 90 days or until the court rules on the motion. So if the court disposes of the motion in 45 or 60 days, discovery commences from there. If the court sits on the motion for whatever reason, you reach day 91, discovery commences at that stage. Interestingly, the motion to dismiss must be filed at the same time as the answer. So I think in theory, under the reading of that rule, if you filed the answer on today, right, and then one of you files the motion to dismiss the following day or the following week, discovery is not suspended. Again, that's just under this quirky little Georgia rubric, but I only say that to point out that each state's jurisdiction, how they are willing to use the Rule 12 arsenal and how it may apply for you strategically is something you're going to need to investigate to get the most bang for your Rule 12 buck. Like every other decision you're making in the federal rules of civil procedure, you always have to keep your eye on a Rule 11 issue. That is, it all has to be based on a good faith analysis. So there are some cases, I put a few in the materials, where a party filed an unfounded motion to dismiss and was found to have done it just for dilatory and improper reasons and got sanctioned. One of them, I think we cite in here, sanctioned is upwards of almost a $40,000 hit because they started playing games with the Rule 12 process. I'm a big fan of the Rule 12 motion for a variety of reasons, and I have had some success filing them, obviously with knowing my Rule 11 obligations, but where they can be used very effective. And I want to point out a couple of these just because once you hear it, we're not suggesting by any stretch that I'm splitting atoms over here or anything really sophisticated, but they're examples that just occurred to me as being strategically appropriate. I'll give you one. Client gets sued. We end up removing the case to federal court, host of other defendants in the case, and we made the decision to file a Rule 12 motion for a lot of very valid reasons. There were huge problems with the complaint, including economic loss rule issues, actually that Jim talked about several hours ago. It was claimed based on a contract and they had auxiliary tort claims with it. For our practical purposes, the greatest advantage of that Rule 12 motion were two. One was we had potential counterclaim obligations back against the plaintiff, and cross-claim obligations for indemnity against one of the other parties that we really didn't want to make on kind of day one, right out of the gate. If we could push those down the road a few months until we knew more, our life was going to be a lot better. This was a financial institution case. While that motion was pending, I actually just went and foreclosed on all the property that was at issue, and I knew if that foreclosure ended up successfully, it would really eliminate a lot of my need to counterclaim on the loan documents and a host of other issues that would otherwise have turned this case into kind of a World War III. It would have been a billing bonanza, but just an effective and very ineffective use of anyone's time and resources. So that Rule 12 motion, properly brought, was done partially motivated at least by an effort to see if I could get other non-litigation efforts to take hold before we had to spend a ton of time and effort litigating a host of issues. Another example, I do a good bit of real estate litigation, and had a case where a party was trying to rescind a real estate purchase contract on a commercial building and suing everyone for a variety of other alleged misconduct. And I filed a motion for judgment on the pleadings solely on the rescission claim, taking the position that they had not rescinded quickly enough or otherwise that rescission had been barred as a matter of law. In addition to just giving myself a chance to take a deep breath. This is a case involving probably 10 or 11 other parties. So you can imagine just the ramp up time in your quick 30 days to figure out what the heck's going on is just not all that easy. I was successful in getting rid of the rescission claim. The motion for judgment on the pleadings was granted. All the remaining claims went forward, and we litigated that case pretty violently for the better part of a couple years. But all the while, I always knew that I had my contract defenses intact because the contract was not rescinded as a matter of law. And knowing that that was always going to be there, I had removed a hammer from the plaintiff. As unlikely as it may be, I wasn't the judge in the case, so I could always just say, I don't think your rescission claim is any good. But if it was still pending, it was always something I was going to have to factor in throughout the case, whether at mediation, trial, or anything else. So getting rid of it very early changed the complexion of the case, at least for my client. I can't say it did the same for all the other defendants who were named. So really, again, think through the use of Rule 12. It doesn't have to be a blanket top to bottom. It could be that quite a few of the claims are very validly brought. You may disagree with the substance of them, but that doesn't mean they are improperly pled. But if you can find a flaw, if you can find an improperly pled claim or one, like the rescission one I identified, where there is a legal defense that can be disposed of out of the gate, that can be a great strategic maneuver for you to start trying to pick some claims off on the case, even before we jump into many of the things that Jim and I have been talking about the better part of the day, assessing all the various potential damages claims. You know, what written discovery do you need? When are you going to do it? Which depositions are you going to need? What's your goal with each deposition? You've eliminated certain pieces of the case, and a simpler case is always easier to assess than something that's got a lot of hair on it. Beyond that, I would caution you, I'm going to talk about summary judgment motions in a couple minutes as well, of some other kind of pleading quirks. And I'll use Georgia again as a good example. I'm not suggesting that all of the Georgia Civil Practice Act is quirky, but we have a couple instances, a couple rules we've implemented that I think are for the good, but they add a wrinkle. If a plaintiff wishes to seek a malpractice claim against a finite list of licensed professionals, attorneys are in there, doctors, nurses, engineers, surveyors, architects, and there's a few more, and only those, attached to the complaint must be an affidavit signed by a professional in that field of work. explaining that they've reviewed the materials and that whatever the conduct is, they believe, they opine, rises to the level of malpractice. It's designed to be a gatekeeper issue to prevent people from just hauling off and filing kind of a Mickey Mouse malpractice case just for the sake of it. There's a little kind of, again, a little bit of a quirky rule in our Civil Practice Act, but that's something you would have to be aware of, and rules like that, even in a different context, certainly I've seen appear in other states' practices of things to consider when you're making sure that the sufficiency of your complaint satisfy all of the applicable pleading standards. The malpractice affidavit thing is just kind of a neat little item that's come up, and that obviously is subject to a variety of motions to dismiss when it's not included or it's included and it has flaws in it and everything else. The counterpunch to a motion to dismiss is time. If your motion to dismiss is going to slow your case down by umpteen months, in the right circumstance, even if you're representing the defendant, you may not want to slow your case down. Having your case pending but on hold or on ice may not be the right outcome if that means 2, 3, 6 months of really nothing substantive happening in the case. You may decide that a motion to dismiss, even if it's available to you, is not the right vehicle. So again, just because you got it doesn't mean you got to use it, but it's just something to be aware of. Going back to the case I identified where we wished to not have to file counterclaims and the like for a variety of kind of business reasons, the exact opposite may apply. We may decide that we have counterclaims and we wish to use them now, so filing a motion to dismiss in federal court, putting the whole case on ice for 6 months, may be a terrible decision in the long run. We want to get our counterclaims going and kind of get the dispute kind of framed as swiftly as possible, rather than kind of stall or drag things out any further. Which, coming off of the motion to dismiss, I wanted to kind of transition into the motion for summary judgment. Presumably we've all, Jim and I included, and our audience, you guys have all been part of the drafting or responding to a motion for summary judgment. Properly done, they should be, a real work of art. They're not anything to be taken lightly. You need to condition your client that this is, short of a trial, the biggest exercise, single exercise in the case. That doesn't mean it's the longest brief you've ever written or anything else. Sometimes short briefs take as much effort as long ones. But this is your opportunity to explain why certain issues are ripe for being tossed from the case. I'm a huge fan of summary judgment for a variety of reasons. I grew up in the context of representing primarily defendants, and have come to see it as a very, very effective tool when used properly. And I have seen motions for summary judgment that really do have all appearances of having been somewhat of a late in the game thought by whoever's drafting it, rather than it being something that was on the horizon kind of way back when. Go back to the beginning of the day when we were talking about assessing issues and really coming up with a plan and modifying your plan as you go through. Most of the issues that will make their way into a final version of a summary judgment motion shouldn't be news to you. Those are things that you should have researched and gotten your arms around long before that motion ever gets sent to the courthouse. In just the way litigation tends to unfold these days, very little interaction occurs with courts. Once cases are filed, there may be some preliminary case reporting with a judge early on, and then unless there are discovery disputes along the way that need court intervention, the next time a judge may likely hear from a party will be in the summary judgment motion. And don't lose sight of the import of that variable alone. That is, judge has maybe in their file a complaint and an answer, and really maybe nothing else until a summary judgment motion is filed, which is a very long-winded way of saying, here is your chance to introduce to the judge kind of what the real story of the case is. And so take that opportunity. I said, put a lot of effort into it. That does not mean regurgitating the Rule 56 standard for 2.5 pages. Suffice to say the judge knows the Rule 56 standard. Spend those 2.5 pages on something more productive. Over time, I have become a huge fan of writing summary judgment motions, sometimes using outlines or graphs or other features that just make them easier to read. As I have read more and more legal filings in my career, I've become probably increasingly frustrated with mundane and kind of adequately and moderately written legal pleadings. So anything that has a little more sizzle to them. Remember, this judge has hundreds of cases sitting in front of him. That poor law clerk is reading thousands of pages of legal filings a month. So if you can make your motion interesting, that doesn't mean ridiculous or unprofessional or anything else, but make it interesting. Make it an easy read. Tell the story. Provide the judge and the staff the information they need to make a decision. So make your supporting evidence easy to find. No secrets. And please do not take liberties with the record. If you think you have support for a certain proposition, please offer it. But don't butcher the support together where all of a sudden it really looks like you're kind of taking liberties. If you don't got it, you don't got it. Because that will have a massive kind of impact on the judge's view of the other analysis that you're bringing to them. Don't also lose sight of a partial motion for summary judgment. If you have a handful of claims against you, you're not compelled to file for summary judgment on all 3, 4, or 5 of them. It could be that some of those claims are just not summary judgment material. That's okay. It's not your fault. So know what you can file for and only file for that. Frankly, you'll probably score some extra credit by saying, Judge, I think I'm right, but I recognize the law has a certain limiting ability for you to dismiss some of these claims, but this one I know needs to be dismissed. That's a pretty compelling way to draw the judge's attention to your partial summary judgment motion. I've really become a big fan of summary judgment. I think it is a way to kind of reward yourself for a lot of that mundane discovery and pretrial litigation analysis we've been talking about all day. It's a chance to shine with some of the information that you've gathered through depositions, written discovery, and otherwise. I encourage you, put a lot of time into it, be a little bit creative with the way you write it so that it sounds compelling. It doesn't have to sound ridiculous, but make it compelling and kind of cut to the chase. Tell a good story and encourage the court to dismiss the very claim that you want to have dismissed. That covers the use of pleadings, even in getting a case off the ground, and how to use certain defensive pleadings to kind of rein in either some or all claims in the case, and then including kind of the big punch, which is a summary judgment motion at the end of your substantive litigation. With that, I'm gonna stop there. I'm gonna turn it over to Jim. He's gonna wrap up your afternoon with a session covering ethics issues on a variety of the concepts that we've gone over today. Thank you.
Well, thank you, Chuck. So that, as Chuck mentioned, our last section of the day is on ethics. And what I want to do in the 4 topics I'm going to talk about here on ethics is to weave in some of the concepts that we've been talking about for the pretrial, pre-civil litigation skills that we've already discussed today. And some of the topics I'm going to talk about here, the 4 topics I'm going to cover, are topics that I already covered, at least in some minor set of detail earlier on, and things that Chuck has mentioned as well. And those 4 topics are scope of representation, and I did talk about this a little bit right at the beginning of the day. Diligence, which I don't think I talked about too much, but is obviously inherent in all work that one does as an attorney. Identifying and avoiding conflicts of interest, I did talk about that a little bit this morning, and I also talked about declining representations. Now we're going to take a deeper dive on the 3 topics we already talked about, and then as well talk further about diligence. Before I do that, though, I think we should all take a step back. When you have ethics issues, and you know, if you're at a big firm, chances are you have an ethics counsel or a general counsel or somebody that you can go to when you have one of these 4 topics, or you have some other ethics issue, or you have something going on that requires good advice and counsel, and for you to talk through it, that you have an ethics counsel. But what if you're a solo practitioner? What if you're a 2-person shop that only has yourself and someone else? I think there's 2 things that can be done. If you don't have a dedicated ethics counsel, someone that keeps abreast of changes in ethics rulings, changes in the rules, changes in interpretations of the rules, you need to find that confidant. You need to talk to the folks at the Bar Association or with the PR folks to make sure you can talk through situations. Because having tried to interpret the rules myself, having tried to look at issues and try to determine in a conflict situation or a scope situation or those sorts of things what the right ruling is, it's often not black and white. It just isn't. And you want to make sure that you've discussed it through with folks and that you've got a good game plan going forward, because these aren't things you want to tread lightly on. I think if you're watching this, you know, Chuck and I have been practicing long enough that, you know, every week when for instance, the Minnesota Supreme Court issues its opinions, invariably, maybe not every week, but at least a couple times a month, there's an ethics opinion that comes out, and everyone can identify someone they know from law school or someone they had a case with or someone they know by other means that has run afoul of these. And you know, knock on wood, I don't want that to be me. So my point here is these things are not to be taken lightly. If you can't get through what should be done and how it should be done, you need to rely on the guidance of someone you trust to make sure you're doing things the right way, so you can stay on the straight and narrow relative to these issues, because they can be easily sideswiped on it. I'll say this too, is if you go to a presentation on legal malpractice and, you know, what are the cases and trends, if you will, that lawyers are getting sued on, one of the big ones is the 3rd item listed there, which is conflicts of interest. Avoiding conflicts of interest, spotting those, avoiding them, acting prospectively is vitally important relative to practice. So let's go into scope of representation. And again, I talked about this a little bit. So can you limit the scope of representation? You can. Do you have to do it in a certain way? Absolutely. So we're going to talk about that. We're going to talk about decision making. We're going to talk about representations by the lawyer. But let's start with limiting scope of representation. We talked this morning about the fact that if you have a client that you've worked on matters for time after time, month after month, year after year, it might be a good time to go back to your retainer letter and make sure that you're doing things the right way, that you're doing things in a way that's going to satisfy it, even though you've opened 10 files for this client or 15 files for this client or 100 files for this client. But if this is a new client, someone you haven't worked with before, someone you're not familiar with, someone you're not entirely comfortable with, not because you don't think they're going to be a good client, but because you just haven't worked with them and you don't know all the ins and outs, it's a good idea to, as we talked about this morning, get that retainer letter in good shape, run it by somebody, make sure it's got all the right features, make sure it's going to be countersigned, make sure you put forward the scope of your representation in as much detail as you can given what you know about the case on the front end. Make sure your retainers are in proper form, make sure what you're asking for, make sure you're doing those things on the front end. So let's talk then about limiting representation. So what happens if someone comes in and for certain reasons you're only going to represent them in connection with this piece? You're not going to you're going to represent them in a transactional capacity. You're not going to represent them in related litigation because you can't do that for whatever reason. You want to then limit that, and I cite the Minnesota rule there. Lawyer may limit the scope of the representation if the limitation is reasonable under the circumstance and the client gives informed consent. Okay, so is it reasonable under the circumstances? I mean, what that means is if you can't diligently and zealously represent the client because there's been limitations placed on you, then chances are you can't represent them under limitation. If you can do so, then you can do so under limitation. The client's got to give informed consent. What does that mean? That means that they need to be informed of it. You may need to advise them that they need to get separate independent counsel to decide that. Whether they do or not is a different issue. You want them to sign something. You want them to be given the opportunity to review that and go through it. And you want to explain it and explain it well. And then you want to get something signed that you can put in your file that if later called upon and there was a dispute, you could say, I went through all this. Here's the countersigned letter. It was laid out in a fair amount of detail, why it was that we were limiting the representation. And again, you got to gauge the sophistication level of your client. Is this a large company with a whole staff of in-house attorneys? That's one circumstance. Is this a small business owner who has engaged a lawyer a handful of times over a 30-year career and you're limiting your representation? You got to know who you're speaking to. And this rule, although the rule doesn't change depending on the circumstance of who the client is, the sophistication level of the client's going to dictate how much of what you need to do here in terms of the conformed consent, in terms of how you lay out the scope of limiting your representation. Again, following on this theme then, I want to talk about decision making in representation. I cite there the Minnesota Rule Civil Procedure, Minnesota Rule Professional Conduct Rule 1.2a. Subject to limited scope and illegal acts, which is good, a lawyer shall abide by a client's decisions concerning the objectives of representation, and as required by Rule 1.4, shall consult with the client as to the means by which they are to be pursued. And again, let's stop there. That all sounds like things we're supposed to do. Now again, you give them advice, you listen to them, they listen to you, and then you make a decision. But what this is saying is a lawyer shall abide by the client's decisions after you've given them good counsel. A lawyer may take such action on behalf of the client as is impliedly authorized to carry out the representation. A lawyer shall abide by a client's decision whether to settle a matter. Again, let's start with the ending point on there. Settling cases, I think we all know, a client's decision is whether to settle a case. And if you ever have a concern about that your recommendation is that the client should settle, and they're telling you, no, we're never going to settle. It's a good idea it depends on the circumstance, maybe in a gentle way, maybe in a not so gentle way, you're going to let them know, here's my advice, you're deciding not to settle it, that's the direction we're going to go. But again, let's assume the other side's offering what you consider to be a fair amount of money and they're not going to take it, and then they go to trial and lose. You don't want them to turn around and say, gosh, we should have taken that, and then try to muddy the water and claim that you told them not to settle. You want to make sure, and I don't want to use the word paper the file, but you want to paper the file to make sure that this issue has been properly evidenced between you so that there's not room for interpretation later. Let's go take a sentence back from there. A lawyer may take such action on behalf of the client as impliedly authorized to carry out the representation. What that's saying, of course, is we don't have to lay out every last thing we're going to do because lawyers have an implication to carry out representation of the client. They don't have to. We're not going to write out every step that one's going to take that's covered within the rules. Back to the first sentence, subject to the scope and illegal acts, you shall abide by your client's decisions. Again, you're giving them advice. Not every client's going to take your advice. Not every client's going to want to do it your way. And you just want to document that along the way. And again, it can be done in a gentle way. You don't want to send them an email every time a decision is made and say, I think you're wrong, I think it's a bad idea, but nonetheless, I'm going to do it this way. It can be done in a more diplomatic way, and it's just something that needs to be documented along the way. And again, that goes back to those red flags I talked about in that one of those slides at the beginning. If this is the kind of client who never wants to take your advice, and I had a client like that a couple years ago where everything we advised them that they didn't want to take the advice. Well, we will end up withdrawing from that representation because it just became a point where it wasn't something that was working for either one of us. And you know, maybe I should have saw the red flags on the front end, but we took care of them later on in the litigation just because it wasn't working. It says there, the second quotation, in civil litigation, the lawyer's errors are attributed to the client. Client's only remedy is an action route for malpractice. Why did I include that? Because if you screw something up, that gets implied, you know, there's an implication to the client. The client doesn't have a claim against the other side. You know, it's not an ineffective assistance of counsel like they would make in a criminal case. Their action is to bring an action against you, or their recourse is to bring an action against you for malpractice. And you know, that's something, of course, that's done after the fact. But the rule deeming a party bound by the acts of his or her attorney is not absolute. Rather, we have recognized as bases for Rule 60B, of course, that would be relief from judgment, attorney's disappearance or mental illness, and obviously those are going to be rare instances when decision-making representation is impaired by some disability of the lawyer. So I would say that's a rare instance. So that's decision-making. Now let me turn to representations. You know, this is something I think that every lawyer takes pretty seriously. When you take that oath, whether it's in state court or federal court, you're an officer of the court, and you have to be candid to the court, and you have to make sure that you know, when a judge asks you a question, that you're not giving half the truth, you're giving all the truth. And you know, when I'm working with the younger attorneys, there's, you know, you have your reputation, you have your reputation both personally and as a firm, and that's not something that you want to let go lightly. So when you're making a representation, you got to think about not just that case, but the larger sense. And if there's going to be some issue, you need to talk about the client ahead of time. But there's never going to be a corner cut on that, because that's going to be an issue that's certainly going to come back to bite you if it's not done and not done properly. In the absence of proof of express authority, now contra, an attorney's representations are not binding when they're later invoked against the client. Now let's go back to the last slide. You know, we said the civil litigation, the lawyer's errors are attributed to the client, but the representations of the attorney are not exactly binding against the client. And make sure there's a distinction there. You know, my lawyer said that is not the same as my client saying that, but my lawyer not doing it correctly is binding on the client as the attorney. So those are not inconsistent, they're consistent. You just have to think through the logic of that as you go forward. So we've covered scope of representation and limiting scope of representation. Now I want to talk about diligence, and this is something that wasn't covered as much, and you know, we could spend hours talking about this, but we talked about a couple of these things right away. And again, you can look at this list and then you can think to yourself, when I see those ethics opinions come across my email, I see ones where people haven't communicated, that, you know, they're neglectful, people that take cases outside of their competence area, disclosure of confidentialities, duty to disclose, spoliation of evidence, acting in good faith, compliance with court orders. I mean, you can take that list and apply those to cases you see, and now you see how that fits back into the area of diligence. Now, we talked about statute of limitations, and you know, there's nothing worse than having a statute of limitations dispute come up, but sometimes they're inevitable based on the case comes in. And again, you're going to want to document that very carefully with the client. If there's a case that comes in that you believe is barred by the statute of limitations, maybe there's an estoppel piece, maybe there's some sort of ratification of a debt or other types of issues that could take it outside of the statute of limitations, maybe there's a discovery issue, something, you know, with a defect or something like that, maybe there's fraud. But you know, you're going to need to make sure you properly document that relative to your representation. And again, if the client's coming in and you know that's going to run, you better be able to jump on it very, very quickly, because one day, of course, if you miss it by one day, you might as well have missed it by a year or 10 years if it really is the running of the statute of limitations. And so, you know, and again, you never want to play it close. You don't want to play it close ever on those kinds of things. I can tell a quick story. When I was a law clerk, we had a case that we were defending where the other side served their complaint about a week before the running of the statute of limitations. And there was a extension of time given to answer the complaint informally in state court. And what it turned out then was, so the complaint was served, there was an extension given. When investigation was conducted, it was conducted and determined that the service was ineffective, and that was pled as a defense in the answer that was ultimately served and filed, and then there was a motion made to dismiss based upon the insufficiency of the process and ultimately the statute of limitations. Okay, well, where did the lawyer fall down in that case? The lawyer didn't fall down because the lawyer didn't get the case out, before the statute of limitations. The lawyer fell down in not knowing the fact that that extension of time, there are two issues. That extension of time did not act as a tolling of the statute of limitations that was given to answer. Number one. Number two, that the ineffective service. And again, that's a tough example because that could happen to anyone, but there's a situation where you got to know what the rules are relative to that. If there's an issue with the statute of limitations, I would be absolutely all over my process server to make sure I'm fulfilling my diligence to make sure that it was properly served. Belt, suspenders, and everything else, because I certainly don't want that issue. And again, that example perfectly illustrates what could happen. It gets served, everyone thinks it's fine, extensions given, nobody's thinking that there's insufficiency of service of process, and boom, then it's identified, and then it answers, and now it can't be cured anymore because the statute of limitations is run. So it's a tough example to prove the diligence that's required, especially if you're right around or right near that. I've had situations where that's occurred myself. I've literally driven the thing to the court myself. Of course, that was before electronic filing. I have personally served service myself, which you can do as an attorney. At least in Minnesota you can. You can't do as a party, but you can do as an attorney, and because I wanted to make darn sure that it got served. So moving on in diligence, let's talk about client communications. And this slide might require a magnifying glass. Promptly inform the client of any decision or circumstance to which the client's informed consent as defined in Rule 1.e is required by these rules. And again, let's stop there. When I first started practicing, again, this is before the age of email and whatnot, it was call with the good news and send a letter with the bad news. Sorry, we lost the case. Well, in this day and age, you can't rely on a letter to send an adverse order to your client. You got to be ready to tough it up and have that conversation with them right away. I mean, I work on a no surprises basis with the client. I don't want them, especially if it's a corporate client, a sophisticated client, I don't want them to be walking into a meeting and I'm holding an adverse order. They're meeting with the general counsel, they're meeting with the board, they're having strategic business decisions, and they don't have perfect information. And certainly, that doesn't mean you have to stay up all night watching your email, but I think in this day and age of instantaneous communications, you're getting an order from the court largely electronically. I guess there's some circumstances where something might be mailed, but those are few and far between now, that you want to make sure the client's aware of things. And again, that's not just decisions or those kind of things, it's other pieces of the case that they need to know about. And again, I think that A1 has been heightened by advances in technology. A2, reasonably consult with the client about the means by which the client's objectives are to be accomplished. And again, we talked about this a little bit before. You got to consult with your client by what you're going to do. And it's a good idea to not only lay that out in some sort of written document, whether that be a memo where you're going to talk about what you're going to do, but to continue to keep clients updated. Send them a status email and say, hey, here's the things we've done, here's what's coming up. And sometimes I don't charge clients for that. I just, I'll mark it on a bill and say, status update to client, 0.3 hours, no charge, just to let them know I'm thinking about them, just to let them know I'm moving the case along. But it's a good idea that I like it when I'm informing the client as to what's going on as opposed to them calling me and asking what's going on. And again, that goes to not only diligence, it goes to one of the other things we talked about, which is client communication and keeping the client abreast of what's going on. And that goes to the next thing, keep the client reasonably informed about the status of the matter. Again, that doesn't mean that, if I'm getting an email here while I'm speaking at a CLE, that I'm going to break from the CLE and go call the client. It depends on the circumstances, but you're going to keep them reasonably informed. That's why the words reasonably is put in there. Promptly comply with reasonable requests for information. They ask for things, you need to get back to them. And again, you're seeing the pattern here of when lawyers get in trouble on this stuff, it's because they don't tell clients about decisions. They don't, for whatever reason, they block it out of their mind, or they don't want to do it, or they don't want to tell them the bad news. And then they hear about it from somebody else, or they go look online nowadays and look it up themselves. You didn't used to have that capability, and now you can go have that capability. In some jurisdictions you could get a copy of it. Other jurisdictions that at least would be noted on the record that a decision had been made. You don't want your client calling you and say, hey, the court issued a decision, what's going on? You want to be on top of that. If you're going to be out of town, if you're going to be in trial, if you're going to be otherwise indisposed, you want to have your secretary watching that, you want to have one of your colleagues watching that, especially if you're expecting something to be coming in that's impactful to the client. Consult with the client about any other relevant information on the lawyer's conduct which a lawyer knows the client expects assistance not permitted. And again, it's all about having a good open line of communication. And again, you got to be careful, because you don't want the client to think every time they pick up the phone or every time you send an email they're going to get a bill for it. That's why I apply a rule that if I'm adding value, I'm going to be billing for it. If I'm not adding value, I'm not always going to be billing for it in terms of extending communication. And the last one, again, these are somewhat duplicative. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions. And again, there's a baseline there, and then there's a sophistication level of the client that you're going to have to take into account when applying that rule.
On the client communication component, so less about being mindful of some ethical benchmark or anything else, but just from the kind of best practices. I'm going to kind of take off of Jim's comment of what he experienced at the beginning of his career about the call with good news, send bad news by letter. I think with the presence of email and texting and those sorts of things, I don't want to sound like the old get off my lawn kind of guy, but I think there is a perception that folks tend to hide behind electronic communications now. And I've seen it with a host of lawyers, particularly less experienced lawyers, where you literally cannot get them to communicate with you by telephone. And I only say that in terms of most of these you're going to see here in B2, I would strongly encourage you to get in the habit of picking up the phone and connecting with your clients. It's a much easier way to kind of have that back and forth. Email is a great way to communicate certain pieces of information. But what we're doing is so nuanced, and you talk about being informed and having input in decisions, that necessitates a certain amount of back and forth, including just stopping periodically and saying something along the lines of, did you follow what I just said, or was that just a bunch of legal gobbledygook? Would you like me to try it again? Because you want everyone to be on the same page. If you're on the same page and things ultimately go south, I can assure you your world is going to be substantially better than if the client at least perceives things were done kind of at arm's length. That's not to suggest that any of these things should not be fulfilled by email, because there is a certain recording then that comes out of that you can't get out of telephone calls. But I would just strongly encourage you, if you're ever debating, hey, should I pick up the phone and call them about X, or maybe I'll just flip them an email, if that's even a consideration, then the vote means it's a phone call. There are certain things that are easy by email. Hey, they're trying to get your deposition set for these dates, tell me which ones work. You don't need to waste anyone, interrupt someone's schedule for that. But when you want to talk about, the court ruled on this, give me a call when you have a moment, I want to talk to you about it, and then send them the court order. Those kinds of things, I think, give you the ability to assess, stay connected, so you're more than just a delivery service. That's just kind of my practice tip of the day. It's a way to make sure that everyone's kind of interpreting things the same way.
Yeah, Chuck, I think you and I are on the same lawn. I would agree with that. You know, there's a lot, you know, and it's the technology that's advanced so much in terms of text and emails and all that, hey, I can just send it to them. No, I think picking up the phone, heck, if they're nearby, having grabbing them for lunch, grabbing them for breakfast, grabbing them for a quick meeting, making an effort to go over there, jump in your car and go over there, that's something that can be done too. But at a minimum, when you're trying to explain something that, like you said, the flexibility or the lack of flexibility of an email, best practice is what Chuck just said. Have a conversation with them, talk to them about it, and then you can send the email, attach the order, and give it more explanation, and maybe that's got to go out to 6 different people, and you don't want to have 6 different telephone conversations, but your primary contact you do want to have it with. And now you can say, like we discussed earlier today, here is a copy of the order, let me explain the finer points, let me explain what happens next. That's what's expected in terms of client communication. Now we're going to talk about competence, which again, seemingly is pretty easy, and what's going on here, what we're talking about is, do you have competence in that area of the law? Now, if I am a general practice litigator and I want to pick up a personal injury case and try that case, can I do that? Well, absolutely. Can I pick up a civil rights case and do it? Absolutely. It just means that when you're taking on that representation, that you're letting the client know that you have competence in that area, and or if you don't, you're going to consult with the folks that do, or you're going to associate or align yourself with folks that do. And if you don't do those things, you can be found under the rules to have not acted competently. So there's not a lot of, it doesn't take a lot of analysis to get where you're going. If you read those quotes, you know, if you don't have the competence you need to go acquire it. If you don't acquire it, you're going to be potentially bound or potentially found to have not acted diligently relative to your representation relative to competence. So it's a pretty straightforward application. Confidentiality. Now again, this gets talked about a lot, and confidentiality in this day and age can be, you know, with all the ESI, and you have clawbacks with the differences in technology. I mean, this is not a course in this, but, you know, are your systems protected? And I'm not getting to any of those things through this slide. That's a whole different issue. Are your systems confidential? We're talking about the more nuts and bolts stuff about not disclosing information, you know, client confidences. And the rules are pretty much laid out there. Lawyers should not reveal information relating to the representation unless they give informed consent. And again, informed consent, I would hope it would be written informed consent, something that evidences what occurred, and it should go back to what we talked about before, that the client, based on their sophistication level, knows exactly what you were doing. May reveal information under B there relating to the representation of a client to the extent the lawyer reasonably believes necessary. And again, that goes back to some of the limited exceptions that are found in the rules of professional conduct. Inadvertent or unauthorized disclosure or unauthorized access to. Again, what they're getting at is you need to make sure you don't disclose client confidences. And again, that can go back to what I just said in terms of your systems. That can mean that when you're at the coffee shop, you're not sitting there with all your stuff laid all over the table and everyone who can walk by can look at it. It means that if you have materials in your car, you're going to put them in the trunk. It means you're not going to leave your car door open so somebody can come and steal those things. It means all those things. You know, you don't want to be able to test the boundaries of that rule if someone steals your laptop and then digs through it. That's a bad situation. But, you know, if you look at the quote there on the bottom, they're talking about confidences and secrets. You know, the ethical duty of confidentiality is not nullified by the fact the information is part of a public record or the fact that someone else is privy to it. You know, everyone learned this in law school, everyone learned this in ethics class, nothing's changed on this. It's just become more difficult because of changes in technology, and you have to make sure that you're keeping abreast of this as things go on. Now, let's apply that to experts. When you're, and we talked about this a little bit, you're going to retain an expert, you better know the rules relative to what you can say and what you can't say to an expert to keep confidentiality, attorney-client privilege confidentiality. You also need to make sure what you transmit to that expert is within that scope, so you're not running the risk of having that situation. And again, it's not any different than consulting with somebody outside of the attorney-client privilege relationship, so that you waive that. And you just need to make sure you understand what the rules are in that regard. And I've listed those, some of those here. Next one, so we're talking about expert, now we're talking about the medical context. Doctors owe a duty of confidentiality to their patients. People know that. Doctor can be, that discloses that, could be liable in tort. Now you can apply that to expert situations. A court concluded it was wrongful for a doctor retained by defense attorneys to interview the physician of the personal injury plaintiff. And we're going to talk about this a little bit when we get to social media, is experts or persons crossing the lines between parties that, using them as an agent to get behind confidentiality. And you see that last bullet point. Attorneys should be cautious not to direct or aid or abet an ethical violation or breach of fiduciary duty. And this is the old school version. We're going to get to the new school version relative to social media here in a minute. Duty to disclose. Clients should be informed of the duty to disclose and supplement. Nothing worse than not going through or not following through on them things and then having Rule 37 sanctions applied because you didn't act diligently. And again, you got to have those conversations with your client. And again, there's a sophistication level, but even sophisticated clients, if they have divergent systems, whether those electronic or otherwise, I think you need to not only know as the lawyer, I have to get all the documentation that we're going to produce in discovery. And I need to understand their systems well enough, or I need to have my ESI person understand their systems well enough, that if I have to explain to a judge that why I didn't produce all these documents, that it is because I made a good faith effort to do that, and the fact that there was a pile left sitting back there was not my fault, because I had to look diligently for that. And again, this becomes tougher in this day and age to make sure that you've gone through all the client files and looked under all the rocks to get there. It used to be easy, as Chuck said, when you had a paper office full of paper and all you had to do was sift through the boxes. It becomes much tougher when they're kept on different computer systems. They could be kept on people's cell phones. They could be kept on personal laptops or what have you. It just requires a level of diligence, but it requires a level of diligence, and you need as the lawyer to understand those systems, like I said, or have someone understand those systems so you can understand that, hey, I fulfilled my duty to disclose and to look in terms of discovery. Spoliation. Clients should be told they must preserve potential evidence. Now again, this is somewhat easier in a physical context. It gets tougher, as Chuck talked about earlier, in the electronic context. You want to issue a litigation hold. You want to make sure that automatic deletes are turned off. And again, you got to gauge the sophistication level of your client. Do they get sued all the time? And the systems are in place, and you can know that you fulfilled your duty under the ethical rules by having one conversation with your in-house contact there. Or is this a family business that's never been sued, and you need to make sure you have instituted the controls to them and they've adopted those controls so they're not getting rid of things. And again, I'm speaking more towards ESI, but it could be towards other things. I mean, if you have a products liability case and there's a product that's allegedly defective, you got to retain that. I mean, so it could be a physical item or it could be ESI. What you're seeing, though, more in the cases is the ESI, because the physical stuff has been around and people understand that better the ESI stuff is you know, the newer issue relative to spoliation. Good faith. Okay, you can't bring or defend a proceeding or assert or controvert an issue therein unless there's a basis in law and fact for doing so. That is not frivolous, which includes a good faith argument for an extension, modification, or reversal of existing law. Now that's the rule of professional conduct. That reads a lot, or, you know, kind of like what Rule 11 would say. But, you know, you hear a lot about Rule 11. I haven't seen it as much in practice in terms of parties being sanctioned. Now you see cases that come across your desk where parties are sanctioned, and that's not where you want to be on the other side. And so you have to take a tough look at things and say, is this a case that's within the mainstream? Is this a case I can make arguments on? And if you can do that, you're not going to have any problems with this. If this is something where, you know, I'm dead to rights on the statute of limitations, I have no basis whatsoever, I'm just going to throw this up hoping that the other side is going to maybe decide they don't want to bring a motion to dismiss and they'd rather pay my client the fees that they would need to spend on the motion to dismiss. You know, is that ethical? I don't know if that is ethical to do if you don't have a good faith argument. And sometimes this is a really, really tough discussion to have with a client to say, you don't have a case, or your case is time barred, and you know what, I can't move forward with it. And if you're not going to move forward with it, and we're going to talk about this in a minute, you need to document why you're not moving forward with it relative to that, so they don't later come back and say, I thought you were going to move forward with it, or you didn't move forward for these reasons, and you told me something else. Now let me contrast what's in this rule. This is, you know, a civil case. If you're a criminal in a criminal case, and they've brought a claim, you know, there's a claim asserted, a count asserted against your client, you know, you can put the prosecution through their paces. You can make them prove all elements of a crime. That is a different standard in a civil case. If you know that what they're arguing or what you are arguing is frivolous, you can't do that. It's different in criminal versus civil, and this rule demonstrates that. This one's pretty easy. Compliance with orders. You gotta follow court orders, and again, that doesn't seem too difficult. But sometimes there's orders that you don't want to follow, but that doesn't mean you get to pick and choose which ones you want to do. One of the pieces that's embedded in that paragraph is talking about withdrawing, and of course, if you're in state court, and I guess it would depend on the state, but I'll take Minnesota as an example. You know, that if you're going to withdraw from representation, all you have to do is satisfy in state court that you're not going to prejudice the client in doing so. And again, that's different in criminal state versus civil state. If you're in federal court, of course, you need to get court permission to withdraw, which goes back to client representation and client retention and client selection. If you're going to appear for a party in federal court and you have concerns about it, be careful about signing up in a civil context, because you need court approval to get out versus doing that in state court. So if those red flags are going up, those antennas are going up as you're meeting with them, and then you realize the case is going to be in federal court, make sure you're aware of how the outs work in state court versus federal court relative to civil litigation. All right, I talked about this before, and I'm going to move on to the third topic, which is identifying and avoiding conflicts of interest. You know, conflicts of interest, I assume, as I mentioned before, people have systems in place. Your malpractice carrier probably requires it, good practice requires it, that you have systems, and maybe you have overlapping or redundant systems to identify conflicts of interest. So you want to identify those. And good record keeping is important relative to client names, business names, slight nuances in client names, slight nuances in business names. So you want to, every time you're going to potentially represent a client, you want to run a conflict of, conflicts check. I talked about before, if I get, you know, my friend the lawyer refers me a case, and the next thing I know, he says, hey, so-and-so may call you, and now so-and-so is on the phone with you, and you're on the phone. You may want to have a short conversation with them, get enough that you can run the conflicts check, and then say, hey, I got to run this conflicts check, I'll call you back, or we can meet tomorrow. Again, there's literature on the fact that if you go too far in those initial conversations and it turns out you have a conflict, that you may have something that's non-waivable because you quote unquote learned too much. Now, if you identify a conflict, the rules, you can go through the rules and talk about how you can gain consent. It doesn't mean that you can't gain consent to a conflict. It just means you need to identify and gain that consent. So this is the list we're going to talk about, and let's dive into more of the specifics here. So conflicts of interest generally. We all know you can't represent one client directly adverse to another client. That's pretty easy. That's, you can't have a concurrent conflict of interest. Second part, if there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities of another client, a former client or a third person, or by a personal interest of the lawyer. Now that's a little grayer than the first one. First one, you can't represent somebody adverse to an existing client. The second one, that's one that you may need to go and talk to. And what is a former client? Let me go to representation. Let's assume I did work for a client, and I started here and I finished here. Is it best practice when you're done with the case to send them a letter and say, our case is now concluded, we're closing our file? Now, do you want to say, and our representation of you is over? Well, you need to make the decision. Maybe you don't want to say that because you want to get more work from them and you don't want to seem like you're being abrupt in your communications. If it's a one-off deal though, and you're never going to see them again, you don't want to take this risk, which I've seen, which is you don't send that letter, you don't make it clear. Somebody, client X comes in 12 months later, and they're going to be adverse to this former client, not on something that would be conflicting, something totally different. You want to take this representation and they say, wait, you're our lawyers. Well, no, I wasn't anymore. It's been 12 months. None of this has to do with anything else. I want to take this case, but you never made it clear here that there was an ending of the attorney-client relationship. Don't be in that position. But again, that's a tough thing to do because you don't generally want to send letters to clients or former clients because you have a pecuniary interest in them hiring you again. So you're going to have to value judge how you're going to do it. Again, best practice would say you would send that file closing letter. Is it going to also say that concludes our representation of you? That's up to you, but just understand the risk that could be run as to number 2 there if that is not made clear to them that you no longer represent them. Clients can consent to conflicts of interest. I just had a situation where I needed to do that. I sat down with our ethics counsel, we prepared letters, all the clients signed them, they returned them, and everything was good. You just need to make sure you do that and do so in a documented way. They have to be informed, they have to be given consent, they have to be in writing, and you need to document that. So yes, you can absolutely, unless it's an unwaivable conflict, you can get consent. Now, there's the consent you can get on the front end of the case, which hopefully you can identify it, and then there's conflicts that can come up during the case that you couldn't know on the front end. And when those are identified, again, you have to stop and make sure you're identifying those, make sure you're running it through. If there is a conflict that hasn't matured yet, but you're aware that it may, we're going to go back to scope and limitation of representation. We can represent you, but if this event occurs, we can't represent you in that subsequent case. I have a situation like that going right now, where I have an existing client who we're doing work for over here. We have another existing client. They have some related business interests. This part is starting to ripple up a little bit. We can represent them both right now, but if they get adverse relative to their business interests, we're not going to be able to represent either one. And so, does that mean I need to say that in my letters right now? No, but if this one's going to be involved in this other case, you want to let them know the scope of a representation may be limited in the future because it would be conflicting as to a current client. Representing clients on both sides of a single claim is non-waivable. Probably a good reason for that. Parties may not waive the legal requirements. You can't do that. Conflicts. Again, if you have good systems in place, you're not going to have this problem, but it's imputed to all lawyers in the firm. It's not a lawyer by lawyer thing. It's a firm thing. And let's talk about that. And it's not a personal interest thing. It's a material, representation thing. And so you're going to want to take a close look at that. And one of the other things that this is not a conflict of interest, but it's something that is coming up is, you don't have a conflict of interest in the sense you're going to be adverse to the client. You have a conflict of interest in the sense of a subject matter of a case. Those are trickier because the rules don't address them the same way they do the straight-on conflicts of interest, but that's a business positional issue that your firm probably needs to decide. Are we going to do plaintiff's personal injury work? Are we also going to do insurance defense work? Because we may have a case over here that doesn't conflict with a case over here. There's no overlapping clients, but I'm advocating to the court, you should change the law over here in this defense case. Meanwhile, I'm bringing this case. How would these two clients feel about that? And maybe you can sit down with them and explain to them why it doesn't matter for either one, but I certainly wouldn't want to have that conversation without having thought through it well as to why I have these positional conflicts of interest. In certain positions, maybe you say, hey, we can do both. Other positions, you say, we can't do both. So that's kind of the positional conflicts of interest. Experts, if you hire an expert, you want to make sure that the expert's done a conflict check so they don't have issues relative to your clients. And I would say the same thing for arbitrators. I mean, I had a situation last year on an arbitration where it was unavoidable, but we gave out the names of all the parties, and everyone was good. Then the parties started disclosing experts and witnesses, and all of a sudden there was an issue. So back to Chuck's point, sooner rather than later to get those names of the experts, get names of the witnesses in a situation so everyone can be aware of those. And an arbitration is a perfect example. It was 3-panel arbitration in that case, and we found out that one of the arbitrators had, they were working, their firm worked with that expert extensively, much more than the other firm was doing. And how do you explain to the client that one of the arbitrators is, the go-to person for that particular expert? Well, we had to get a new arbitrator. And again, I don't blame anyone because it came up and it came up as quickly as it could, but it was not fun to have to stop the presses and go get another arbitrator and reschedule the arbitration because of that issue. So as soon in time as you can identify, the better to avoid that. I have this piece about witness tampering. I guess that's, again, pretty self-evident that lawyers can't tamper with witnesses, so I'm not going to spend too much time on that. Just on the topic of conflicts of interest, you can't provide legal advice to a pro se opposing party. That can create a conflict of interest. And again, even if they're not an opposing party, what if they have an aligned business interest with your client? You got to be careful in your communications with them because you don't want them to perceive you as having given them legal advice. You call them and say, well, my client's doing X, Y, and Z, and they, because you're the lawyer, expect that you're instructing them to do or not do something. I'm not your lawyer. You want to make that clear to them. I represent this client. I don't represent you. And if you need to put that in writing or document that some way, you should do that, because you may have an unsophisticated pro se party who changes position based on something you said and may have good reason to do it, and then comes back later and says, well, I thought they were giving me legal advice. You don't want to be doing that. Your advice in that circumstance should be you should go get your own lawyer and make your own decisions. And that can be tough to do because maybe you don't want to invite them to do that. Maybe they don't want to have the cost of having to do that. But you just want to avoid that situation because although the business interests could be aligned now, later on maybe they're not aligned, and you don't want to be in that situation. Conflicts of interest in bankruptcy. Again, there's different rules for bankruptcy that you have to be aware of in terms of the debtor in possession, disinterested parties, those sorts of things. I'm not going to spend too much on that. I talked about this a little bit, conflicts of interest arising midstream. Again, sometimes they're unavoidable and they're not things you can forecast. But if you haven't done the screening processes on the front end, you're not going to get cut a lot of slack. It has to be an unavoidable conflict of interest that arose midstream and not something that could have been foreseen or taken care of on the front end. And that's the Fourth Circuit case, disqualification of the attorney. The last thing you want to do is to have to go sit down with your client and say, hey, we're going to be disqualified, or I'm going to be disqualified from representing you because I didn't do the stuff on the front end. Now they're going to look at you and say, oh, do I get my money back? Are you going to disgorge my fees? Boy, there's a conversation you don't want to have. So this is again why conflicts of interest checking and trying to do as best you can, and you're never going to be perfect because there's no way to be perfect, but to do your very, very best and document it along the way. Social media, I mentioned this. You know, you can't instruct your paralegal to go friend the other side on Facebook so that they can learn about everything they know on there. That seems a little self-evident, but there's all kinds of cases now rising from social media where people are doing that, where they're creating, you know, and I don't know if conflicts of interest is the right term, but they're creating, you know, they're trying to breach maybe the other side's defenses that way by doing that. And so, you know, again, not to be the fun police, but I think when you're an attorney and you're working with pro se parties or working with persons that aren't attorneys, you need to be very conscious of how you're using social media, whether that be Facebook. I mean, I've had cases where a case is concluded, I've taken the deposition of the other person, the party on the other side, and then 2 months later I'll get a LinkedIn request from them. But, you know, hey, we met during the case, and now are we still adverse in litigation? I guess not. The case was settled or it was resolved in some way. But I'd be very cautious about that. What if they're trying to set you up? I mean, you don't have to be everyone's friend on Facebook. You don't have to be everyone's friend on LinkedIn. You know, I actually had one sent to me during the course of litigation. I turned it around and sent the email to the other attorney and said, can you have your client stop trying to friend me on Facebook? Can you have your client stop trying to link to me on LinkedIn, because I don't want that situation. You want, you know, everyone wants to be online, everyone wants to be involved in social media, it's all fun. You just got to be very cognizant that it can create issues, and they can be created sort of innocently too. Now, I made this point to when Chuck was talking earlier, and this bears on this a little bit, but it bears on the issue of, you know, if you have clients that you know spend a lot of time on social media, whether that be promoting their business or you know, just they're out there all the time, you want to make sure, again, you're not trying to limit their business, you're not trying to tell them what to do, you're not trying to imply to them the standards of a lawyer. You know, you're going to get accused of cutting their legs out. What you do want to do is make sure they're not giving away, you know, I had a meeting with my lawyer today. You know, one of my wife's friends was getting divorced, and every time she met with her attorney, she would go describe the discussions she had with her attorney on Facebook. And you know, I see Chuck over there cringing, but it happened, and obviously that attorney didn't tell her, hey, by the way, when you and I have a meeting, it's not something you can go talk about on Facebook. And again, people think there's this line between their personal and their business or their legal, that there's no overlap, and it certainly does overlap. You know, you don't want your client texting other people and destroying client confidence or attorney-client privilege communications. So you want to, in this day and age, sit down and talk to them about that. You know, the other thing too is you know, and this goes back to the old surveillance days in personal injury cases when I was doing defense work, is you'd go have somebody, you know, you'd have surveillance put on someone to see if they were, quote unquote, faking their injuries. Nowadays, you can go on Facebook and say, oh, there's a picture of them running a marathon. There's a picture of them doing calisthenics in their front yard. You know, if I'm the personal injury plaintiff who has those issues and is claiming to have those issues, bad idea to be putting those on Facebook, because pretty much assume that everyone's going to look at that, or Instagram or Snapchat or any of those other things. Now, the conflict comes in and the PR issue comes in if you're gaining them as a friend, so to speak, just to look at those. So you can't, as the opposing party, explore those issues unethically. You have to do that through ethical means. And a lot of people don't make their stuff on Facebook, for instance. They don't put any restrictions on who can see it. And if I just have to go on, I don't have to friend them and I can look at it. It's the way it goes, and that's just a bad idea. Okay, last slide and the last issue of the 4 is declining representation. And again, we already talked about this a little bit, but let's be clear. You meet with a potential client, and for whatever reasons, whether it's one of the red flags we talked about, whether it's other issues, whether you don't think you have the substantive knowledge, you don't think you're going to work well with them, they can't pay your retainer, whatever, you want to make sure that you send a letter saying we're declining or terminating representation. Why are you doing that? Well, first of all, you don't want them to think that you're actually representing them. So you've let them know we're not. Number one. Number two, you want to do that so you've established in time that they're no longer a client or never were a client for the reasons I mentioned before for potential future conflicts. That's another reason. Now, we talked about on that second bullet point, continuing representation may be required. You know, you can't, even in state court, you can't withdraw if it's going to materially prejudice the client. That's a value judge you have to do. And boy, I don't want to get that wrong, because that goes back to they can bring an ethics complaint against you, they can bring a malpractice claim against you. So best discretion is that you're going to make sure that when you do so, you're doing so for the good and proper reasons, and you're documenting it. And I'll tell you, if you're in state court and it doesn't require you to get court approval to withdraw, doesn't mean you can't seek court approval to withdraw and document those reasons to a judge, and you can do that confidentially, and that would be a way to cover yourself if there's such an issue. And again, what's going to happen in that circumstance? Let's assume they haven't paid your bills for 6 months, and there's 3 months to trial, and it's going to cost another $100 grand to put it to trial, and they have no prospect of paying you. You know, now you better have a good letter, you better have a good estimate, you better have good retainers, you better have the other processes we talked about earlier, so that when you put that issue before either a court or some board later, that you can say, hey, I documented this from day one, and I should be allowed to withdraw because I made it clear that I would withdraw. I sent them letters along the way saying you haven't paid the bills. If they're not paid within 30 days, we're going to do this. You want to keep a constant flow of communication. And again, it doesn't mean it has to be heavy-handed. It doesn't mean it has to be fire and brimstone. It doesn't mean that it's going to be something, but having good documentation is going to be important. The letter of termination. If there's a termination, you want to make it clear. Just, we talked about declining representation, continuing representation, terminating representation. That last point, the client must be permitted to retrieve the file regardless of payment status. You can't hold the file hostage, and that includes the electronic file or the paper file. And there's limited exceptions. They're not entitled to perhaps copies of all your personal notes, but in terms of pleadings, research, they presumably paid for that research. They paid for the correspondence. They paid for that file. You can't hold it hostage. You've got to make it accessible to them or to their new attorney. And again, you want to document that to make sure that what they're, you came over, you looked through the file, and we gave you these materials, and you want to make sure that that's documented. And if you don't trust yourself to go through it and document it, have someone else in your office that you do trust do that. But, and again, back to my point before about declining representation, when you close a file, you'll have to make a decision whether I'm going to send a letter to document that the file's now been closed, so that if there's a conflict situation that occurs later, you have documented the fact that they're no longer a client. And again, maybe you don't want to do that because you want to get continued work from them, but understand if you don't do it and they later claim that it's too close in time. Now, if the future representation of another client impacts what you already learned about them, well, you can't take the case anyway because you know too much to do this. We're talking about cases where there would be no overlap between those. And again, if there's going to be an issue, my point would be I'd rather not get involved than get involved, because I wouldn't want to put myself in a situation where the client is claiming that I used confidences or secrets or information learned in one case against them in another case. That would be a bad, bad idea. So with that, I think we're done with the ethics presentation, and that concludes our presentation for today. I want to thank my co-presenter, Chuck Van Horn.
Thank you, Jim.
For a good day, and I want to thank everyone at MBI as well. That concludes our presentation, and we thank you for joining us today.